collegefootballnerds.com. Gonna get nerdy today with y'all with some off-season content, but it's not what you're used to from us. No statistics today. We're gonna get legal nerdy with you. As you may or may not know, we've talked about it a couple times before, Josh, my co-host, is an intellectual property attorney for one of those big fancy law firms, and he is also a huge dork, so he's published a good bit of content on this very topic. And we're going to have some discussion about it today. It's the NCAA football game. It's been, I think it's since 2014. It's been gone from us. We want to talk about what happened, really, and kind of the roadblocks, the legal roadblocks that have been presented since then, and maybe if there's any way for EA or some other company to pick it up and take it forward, what would those possibilities be? And we want to be a little different than normal because we think y'all are probably all familiar with this at this point. So we're going to hit the high notes quick and then get into some meat that you may not be familiar with on this case, with this game. We all want to find a solution to get our NCAA football back in our hands. As much as we love Madden, we need some college football too. Before we get into it, please subscribe, please like, share it, let your friends know about us, and let us know in the comments, were you a Bill Walsh college football guy or gal, or did you play some other version? I think there was an awesome version on Sega only that was pretty cool. It was the one where you could like lift your helmet up after you converted a first down and touchdown, whatever. Let us know in the comments which one you liked, and if you're playing 2014 and you got a channel, maybe let us know that too. All right, Josh, long intro as usual. Just get us into this real quick. Give us a high level overview of like what the game was, why they were treading in maybe some legal gray area waters, and maybe sort of introduce us to the court cases that sparked basically the demise of the NCAA football series.
Right. So I was a super play action football fan on Super Nintendo, just throwing that out there. But, all right, yeah, first off, and I have to say this because of my position, but these are my opinions. These opinions don't represent anyone, any organization that I'm affiliated with.
They probably represent the College Football Nerds Association organization that you're affiliated with. And they can go ahead and represent me too, since you know more about it than I do.
Fair enough. Yeah, but these are our personal opinions. So there's three cases that were brought up around the same time that all influence the current sort of landscape of college football games. Those cases were Hart, Keller, and O'Bannon. Hart was brought before the Third Circuit Court of Appeals. O'Bannon and Keller were brought before the Ninth. And for those that aren't terribly familiar, the Court of Appeals are the level of courts that sit right below the Supreme Court. They're predominantly, to a large extent, they're the courts that really set the law for most of the country. But the way it works is a Court of Appeals is assigned a certain number of states. And a lot of people aren't aware of the fact that one Court of Appeals, when they put a precedent or have a ruling, it somewhat sometimes applies nationally, especially in an antitrust case, which O'Bannon was. But it's really only binding to the states they control. So sometimes a circuit, like the 11th Circuit, which would be the Southeast, Alabama, Georgia, might be different than the 9th Circuit, which is California. The 9th Circuit was O'Bannon, and something notable about that, one, they tend to have a little bit more of a strong stance on individual rights, and two, it's 20% of the population of the United States. So the 9th Circuit is often considered to be the most influential in a lot of ways because the amount of population covered by the 9th Circuit is so large.
And they probably have the most Supreme Court cases because of that.
Right. There's a lot of cases on the 9th Circuit. You'll hear a lot of political stuff. We really don't want to get into that. But something just to bear in mind that a lot of the reason why they're so, famous or infamous is the fact that 20% of the population is under the 9th Circuit. That means 20% of the people committing crimes or, stealing from one person, committing fraud, they all happen within that circuit. All right, so the three cases, Hart, Keller, and O'Bannon. First, I'm going to start with Hart and Keller, actually, not the O'Bannon suit a lot of people are familiar with. Hart was, kind of the earlier case here, and Hart really dealt with the idea of, do you have a right for your appearance to have in a video game? Before we got into this whole contractual issue with the NCAA and whether or not the players had the ability to, withhold their rights or to maintain their rights despite the relationship with the NCAA, the first thing the courts had to figure out was, did that even matter? Was there an injury? If you didn't have the ability to gain money from your likeness in a video game in the first place, then all that NCAA antitrust stuff about that relationship wouldn't have even mattered because there was no money at stake. So the courts often first turn to the question of whether there's, what it's called in the legal world, whether there's an injury, whether there's something for which money to be gotten back.
To put this into perspective, I don't know if this is analogous at all, but courts have ruled time and time again that people in the public domain, like I'm a photographer, I love photography, and street photography is completely wide open. I can go out on the street and take a picture of anybody, including your kids, which I don't do. It's kind of weird when people do that, but and you can't sue me for it because you're in the public domain. So when you talk about injury, is that sort of analogous where the other side is, I can't demand money from somebody taking my picture out on the street, and maybe this is kind of a similar situation?
It is to a certain extent. Now, there's a long line of cases for something called right of publicity. And again, I'm an intellectual property attorney, and there's a lot of different types of intellectual property. There's patents and copyrights, trademarks. They are all very different. They have different bases for why they exist. The general idea with the right of publicity is, at least, particularly while you're alive, you have the right to use your own image if it's a famous image. Somebody can't, take a picture of Michael Jordan and slap it on their advertisement and put it on, in a commercial that runs in a college football game every 90 seconds. Not that we've seen the same commercials sometimes on college football games on repeat on certain channels, but you do have some sort of right of ownership to that. And the idea is all rights are sort of legal constructs, right? The fact that you own anything intangible is a legal construct, and pretty much all intellectual property is intangible. Your copyright ownership, your trademark ownership for the name of your brand or your channel, patent ownership, the idea of owning an idea itself, or that's all abstract, right? It's all intangible stuff, and we sort of take that and we pretend it's a real thing that can be transferred and owned. But one of the things that has been created is this idea of a right of publicity. So what that says is, if I as an individual have my right used, I should be compensated. And in this case, the question sort of extended to how far does the right of publicity go? How much of a likeness does it have to be? So that was kind of your first question. Ryan Hart was a quarterback for Rutgers University from 2002 through 2005. He took his team to the first bowl game in 1978. Okay, since 1978, to be clear. His number was 13. He was 6'2". He weighed 197 pounds. In the video game, all those details but the name were copied. So the court noted in their decision. So this isn't really my opinion, but this was the court's analysis. The avatar resembled the real Hart in his hair color, his body type, his hairstyle, his skin tone, and even the choice of accessories he wore on his body. He was the quarterback for Rutgers at the same time period that he was playing in real life. And so you had to figure out how much of that is a real likeness. Now, one of the questions with video games, that without going too far into a tangent here, is it's not a picture of you, right? It's an avatar that's a likeness of you. How close does that avatar have to be to you for it to be the same thing?
So that kind of leads me to the question, because I think that is pretty important. Because the likeness, like you said, weight, hair color, getting down to the avatar, the representation of the person in the game without the name. And so for a long time, the NCAA did that, or EA did that in their NCAA football games. And I think other game makers did the same thing, where they basically gave you Rutgers football team or whomever. Probably nobody played that Rutgers team, so I don't know how much injury he could claim. But then later on in the series, they got into where, yes, you could have the creative player and people built their own rosters out. But for the most part, if I remember the last few years, maybe even more than that, they got to where it was the player quality for the teams were on par with the real life team in aggregate, but the player roster was completely randomized. So for if it's Auburn, the Bo Jackson back in the day, they'd have a 99 running back, but he might be a white guy, or he might be a 6'3", thin, long gait with dreadlocks black guy, which doesn't resemble Bo Jackson. So is this, and this gets into speculative waters, and I don't want to do too much of that here because I want to talk, case law and facts and where we're going to go with this. But because this game for EA and other game companies wasn't a super money maker, is it possible that the randomization of the players' attributes, physical attributes, long term would have been a sustainable model legally that they could use as a crutch, and that they probably would have pursued had it been a huge moneymaker, like, say, the Madden series?
I think there was an argument that if they had made players completely random, that they could have avoided this issue. Now, I don't want to go too far down that road because, as you said, I want to stick away a little bit from the legal speculation. The court held in the case that the realistic depictions of the players are the, quote, sum and substance of the digital facsimiles. So in the court's view, the way the players were actually portrayed in the game as it was, where they were all pretty similar, was the sum and substance. And there's something called a transformative use test, whether the likeness is transformed into the medium such that it's something different. And if it's transformative, then you don't infringe this anymore because it's not the same thing as your original likeness. It's some sort of transformed use. That's a lot more. I'm not going to get in the weeds on that. When you start dealing with the idea of randomizing the players, one, if it's completely random, then I think the argument for the player's likenesses starts to go away. The fact that you happen to be the quarterback at the same point in time probably doesn't have as much relevance if the players are all completely random. The question becomes really, at what level does that need to take place? Which I think that question is never completely answered in the courts. They always want to deal with the facts in front of them. And the facts in that case, I think, were, as long as there are certain players in there that you can recognize who they are, and that you can sort of deal with the fact that you're playing, the football game, and you're playing essentially alongside of, or as the court put it, the point of the game lied in users' ability to play, quote, as or alongside their preferred players or team. So if you're able to play alongside your favorite players, as long as you were in a few of them on there, then those likenesses have sort of an impact on the game, so to speak. That all kind of speaks for it. If it's completely random, I think they probably kept it going. If it was completely random and you don't have this issue where the individual players aren't there, then you don't have this likeness issue because it's tied to individual rights. And then I think the next issue you have to understand is the individual rights of the players were separated in this case from the ability to identify Alabama or the stadiums or anything like that, because that issue or all those IP was actually licensed from the universities. The question was whether those licenses should have covered the players, one, and two, if they did, if there was an antitrust issue, which got us into a Bannon.
Right. So the CLC, Collegiate Licensing Corporation, I think they're based out of Atlanta. That's who you go to. If you buy an Ohio State t-shirt, that's an officially licensed piece of merch, they license that through the CLC. If you buy a spoon that's got, the Texas Longhorn on it, it's got Bevo on it, they went through the CLC. And that's something that they can do for the team logos and the stadiums, and being able to say the phrase Auburn Tigers or Tennessee Volunteers in combination with the colors, down to the hex color value, stadiums, campuses, all of that. That can be part and parcel, one-off, licensed through the CLC, paid a single fee or variable fees per team, per university. They all have their own deals. But one of the issues here, unlike the Madden games where they can license through the NFL for all those same things, but then they can license through the NFLPA for all the individual names. And if y'all remember, I think it was like 3 years ago, there was a year where they didn't have MLB The Show on PS3 or PS4, or they didn't have a baseball game on Xbox. Maybe somebody help me out in the comments. Maybe 2K had backed out. And RBI Baseball came out with a game, I think it was RBI Baseball. They came out with a game where they had the teams licensed, but they didn't have the Players Union, licensing, so they didn't have the names in the game. It was something like that. And this would be similar in that you don't have an NFLPA, right? Is that what you're saying? Like, there's no unifying singular body that you can go negotiate with or collectively bargain with as it relates to college football players?
Right. So we spent a lot of time talking about Hart, and that was important to understand what was the actual right at issue. Okay. Now that it was determined that there was a right and that the players had some ability to get money for it or should be given money for it, the next question is, was there a contract for those rights? And if there was a contract, was it valid? There were two other cases, right? So Hart was in the Third Circuit, and that's what we've been discussing to this point. The other one was Keller, which was a quarterback for Arizona State and Nebraska. As the court put it in that case, he was used in the video game. He was what he was, quote, the starting quarterback for Arizona. The game setting is identical to where the public found Keller during his collegiate career on the football field.
Can you explain why, sorry to interrupt, but can you explain why it was necessary to have another, did the Hart case not set enough precedent and they needed another case like Keller and then subsequently O'Bannon? Was O'Bannon when the class action started and the other two were individual? Explain why the Hart finding, which sounds like it was similar in the Keller finding, why the Hart finding didn't cover for all. Is it just the circuit court thing or is it something else?
It's a combination of all those factors that you were mentioning. So it's quite common that when you bring a court case, it can take several years, right? And I frankly, I'm not 100% sure. I'd have to look at the exact timelines between these cases. But suffice to say, Hart, Keller, and O'Bannon were all filed very quickly together in time. I mentioned the Keller case. O'Bannon and Keller were both filed under the Ninth Circuit. They were filed separately, and then they ended up being joined together and appealed to the Ninth Circuit from their district courts. All these cases were kind of overlapping to at least certain extents. Now, as memory serves, the Hart decision from the Third Circuit came before the O'Bannon-Keller decision in the Ninth Circuit, but Hart was a little more specific about that, his individual rights. But what that didn't get into is whether or not those rights were infringed for everybody. And what O'Bannon brought in particular that made it such a big deal was an antitrust component. So what O'Bannon said was, not only did I, have my own rights taken away, but all us players had all our rights taken away doing an antitrust violation. And the issue there, to your point earlier, and this gets to the answer to your question, the NCAA had licensed and the CLC had licensed the rights to all these things to EA Sports in these cases. But there was a question of whether or not the players themselves, one, whether their rights were properly sort of consumed due to the contracts they signed when they take on the scholarship, so the university could use all their likenesses and whatnot. And then two, if not, how that would work. So the antitrust component said the NCAA and their licensing agreement from the players was improper, that they have total control to take away all the players' rights and the players don't have proper bargaining position, if you will. That's the Sherman Act antitrust stuff. I don't want to get into that too far because, one, I'm not an antitrust lawyer. I don't know a ton about it. I understand it generally, but I don't know the nuanced specifics. But the general point there is they didn't have the proper contractual ability to make these to give away their rights to the NCAA, because the NCAA essentially was a single entity that held all power over college athletes to tell them, you're going to give away all our rights and you're going to get one scholarship in return, and you're not going to be able to bargain for this at all in any way. So what you needed was a way to actually bargain with the players. Now, I don't want to get into the issue of whether or not unions are good or bad or anything like that, but the point is the only solution here is that the players have to be bargained with as a whole, separate from the NCAA. The route around all this stuff that happened is, we have all these decisions now, Hart, Keller, and O'Bannon. One that says they have a right that was infringed. Two, O'Bannon going a step further before the Ninth Circuit and saying yes. And by the way, all these contractual relationships with the NCAA, they're too forced on the players. They're not allowed to do that under the Sherman Act. It's a commercial violation to have one party with that much control contractually. You need some sort of union, like the NFL Players Union or the NFL Players Association Union, or you need something else that allows EA Sports or whoever wants to make a video game to be able to come to an agreement with all the players so that the players can independently give their rights to the video game organization in a way that doesn't, a CBA that doesn't violate antitrust law. There's a couple ways I know of to do that. One is the Players Association example. Another would be a clearinghouse. Those are the two that have been kind of proposed.
And so what we saw from EA in this instance, after the O'Bannon case, I don't think each player was awarded that much money. And I think some were awarded more than others. But again, I'm speculating, not Josh here. I'm speculating that if it was a huge moneymaker to EA, then they probably would have pressed harder for more randomization and less of one-to-one players, and maybe even killed the ability to download rosters from lockers, where if you wanted the full NCAA experience with the players and the names and down to the tattoos and the hair, you'd have to do it yourself. And otherwise it's random. I also remembered one other instance where this happened recently. NBA 2K, I think it was 18, maybe 17, actually had you play in the Final Four. You play like your last game of college basketball or whatever, and it had like Kansas and Duke, and like it had like 4 or 5 teams in there, and they were completely randomized. So they have technically had college basketball since this case, which is kind of interesting because it touches on what you said. There was no need for a CBA, and probably couldn't have players in there because there was no CBA or was no possibility for that. But we have seen college teams represented in video games since then.
Well, Madden had the long shot mode too, right? Where you were a high
Yeah,
school
you were
player,
Texas.
and you had Oregon or Texas.
That's right.
And you played as, again, that is complete, because it's completely random, and importantly, it's problematic at a lot of levels, and we're not sure where the line is, right? How much do you have to look like a player? Is it enough that running back 1 is the best running back in the country, running back number 2 is the 13th best running back in the country, where clearly running back number 1 is Saquon Barkley because he's so good, despite how good whether or not he actually looks like Saquon Barkley? Maybe there's an argument that just his ratings alone would look like Saquon Barkley. We don't know the answers to all those questions because all we know is the facts in front of us, which were a lot more, maybe arguably more similar than that. But yeah, no, they could do a random thing, but that wasn't what happened in the past. I think the problem, like you said, half the issue is how much would people pay for these games if the players didn't resemble the players in the real teams. I think that spoke a little bit to the video we did on the AAF, may it rest in peace, that fans do have a lot of ties to the college teams and the players, and a lot of the interest in the AAF came from that in the same way a lot of the interest in the NCAA football games did. So it's probably telling to a certain extent they're not trying to move forward beyond like a hook in the Madden games, because without those likenesses, it doesn't really work. So because of that, that whole argument was something the courts noted. I should point that out. The courts were aware of the fact that people played these games to a large extent because of the players, and that really makes the players' cases a lot stronger because it says their likeness was that much was adding value and was important to the case. That's kind of an interesting and important part. There's been some other things in video game cases. There was actually a strip club that appeared in a Grand Theft Auto game, and there was a trademark case on that. And one of the things that came out in Rockstar's favor was they pointed out, look, nobody plays this game in any way because it was a parody of a strip club, by the way. Well, Rockstar was in pretty good shape in that case, but nobody plays this game because this strip club was reproduced on this one street corner that was obviously a parody of Los Angeles.
Sidebar, do you know if they had to settle with, was it Miley Cyrus? Who sued them saying that they were the cover model for GTA 4? Their likeness.
Oh, it was Lindsay Lohan.
Yeah, that's it. You can forgive me for getting them confused, but he's looking it up right now. I thought he would know this. This is why I bring the attorney on the show.
I am 99% certain. I just wanted to double check. Yeah, she lost that lawsuit. Well, there's sort of two sides to it, right? And that's why I kind of wanted to go off that tangent for a second. It's not just how much of a likeness is it, but it's also how important is it to the product. All these tests are kind of squishy, and a lot of it's because it starts to deal with the idea of free speech, and that's why these things get as squishy as they do. And a lot of people hear about the term fair use. I'm not going to go into detail about that, but I will say a lot of people use fair use a lot more than you should.
Yes, on YouTube, by the way, y'all, every hype and highlight video in the world, and every time someone steals somebody else's content, they just slap it up there on YouTube, and then in the disclaimer in the description, they just say, fair use, I don't own this, here it is. And I always think that's funny. Anyway, continue.
Yeah, those tests, they're balancing tests. They're balancing individuals' property rights versus the right to free speech. But one of the things that always takes a big step forward, and pretty much all those tests, is how much money was the likeness worth? How much money was your original content worth? And that's why you have like a transformative aspect of, yeah, it's kind of your likeness, but it was made into something completely different, and the value was whatever they made it into. It wasn't what it was originally. And in the NCAA cases, one of the things the courts did find is there was a lot of value in the identity of the players being recognizable in these games. Again, the strip club and GTA example, not a single person played that game, or maybe two people somewhere played that game because that particular business was in the game. That stuff does matter.
A good example of that also on YouTube is if someone is breaking down film on YouTube, they can usually monetize that video for themselves. We don't do it a lot because, one, it's hugely time consuming, and two, we still want to be careful because our original channel did get taken down because of copyright strikes. So you have that side where somebody uses the game film or the broadcast, and they use small snippets to break down specific game film per specific performance. They are creating most of the value there, whereas there's a lot of other people who just post full games. There's no commentary around it. There's no insight into it. They just post the full game. 100% of the value there is the game, where 100% of the value is the commentary on the other side. And what you're saying is it's for these players, the value they added, the courts rule was somewhere in between.
Right. And I'm not going to speak to whether or not you're right or wrong on your assessment of that stuff, because fair use is squishy. I can't give you a hard or bright line rule. Again, we actually, in the real world,
I'm just saying what YouTube
circuits.
has decided based on all the times they've been sued about it.
Fair enough. From a practical aspect of whose stuff gets taken down or doesn't get taken down on YouTube, which I think is your point.
Right.
Yeah. The game, if you're breaking down film and you have a 8-minute clip of which 30 seconds total is from a broadcast, part of that gets into this idea of newsworthiness too. And I can't point to a case. I can't tell you exactly how it comes out, but that does start to at least maybe push a different direction. I don't want to go too far down that road.
Why don't you sort of break down, you mentioned there was some ways that you saw that this could be sort of cleared up and give us, a game in the future. In your mind, what are the ways, or what is the way or ways forward that you could see if you're looking around the corner that could bring us to a resolution and not only pave the way legally for a company like EA to make a game again, but to make it that the risk is low enough that they'd be willing to do it knowing that it might not be a cash cow?
So there are two ways, and I can't say for certain whether or not they would work. I think you'd have to do them and just sort of see how it plans out. The first would be if the players unionized. And there was already kind of one attempt with this, right? With Northwestern football, their players attempted to unionize. There was a whole process involved, and it didn't really succeed. The players ran into a bunch of obstacles with it. It was I believe the College Athletes Players Association, and they weren't able to put it all together. If that had happened, if you'd had a players union, the players union, just the way the NFL Players Association licensed out the likeness of players in certain aspects, the players union could have negotiated on behalf of the players, and all the members of the players through the union could have gotten some amount of money shared from, whatever the video game is, college basketball, college football, etc., split through the union to the players, and in exchange they give up their likenesses. That would allow the players to give away their rights in a properly bargained manner that hopefully would not violate antitrust law. You could have your football game. The players would get some small amount of money. As you saw, we talked about this briefly with the O'Bannon case. The amount of money per player here isn't huge. The reason is there are so many players in the game. The profits in the game were not astronomical given that the licensing fees in these games are quite high. So the value of the players isn't maybe as high as some people might think. But that would allow the players to get compensation. And as long as they're getting fair compensation, then this can go forward.
And it's also the case, isn't it also the case that this doesn't require every single player in, say, D1 football to sign on? Like if there was people who weren't part of this CBA, they would just get left out of the game. I think Bill Belichick in the Madden games still gets left out. Michael Jordan in the basketball games was not that didn't allow his likeness in the games. I think Charles Barkley as well. So would that be the case here where because I could see it being a pain in the butt to have to go to every single player and get all of them to agree. But would this be like, well, we've got 90% of the players and then 10% just get left out of the game completely and that's how we're covered?
Right. So I think you hit on a point that we probably really should have addressed earlier. I mean, one of the main issues is, as it stands today, you would need to go to every player individually and contract every player individually for their rights and likenesses, and then provide compensation to be able to use their rights. But the NCAA doesn't allow you to do that, right? To have an endorsement deal with a player and to buy their likenesses like that and compensate them. So it's a violation of NCAA amateurism rules. So there's two problems. One, you've got to be able to get all the players on board, or at least enough to form a team. And two, you have to be able to pay them in the first place without making them commit an NCAA violation. So, and to your point, if they did that, if they had a CBA and you were allowed to, do something through the CBA, and then the money would probably be spread equally across all the players in the sport, and the NCAA might not have a huge issue with that. They probably could write a resolution to that. I can't speak to exact terms, but that seems like something that might be feasible. In that case, yeah, the players that don't agree under the CBA probably just get left out, because there's probably, one, it's going to be too hard to talk to all those guys. Two, if you did talk to them, maybe that falls outside. There would be some exception where contracting with the College Football Players Association is okay for the money to be split equally, but you couldn't do it individually, so that might be a violation on its own. Maybe they opened it up entirely to endorsement deals and you could do both, and certain players would demand more money to go in, but it's more than likely that I would think for business reasons, you probably wouldn't want to do that because you don't want to deal with holdouts. There is a second option, though, and that is, one, we're talking about a separate entity for the players create. The other thing is the NCAA could create its own entity called a clearinghouse, and the clearinghouse could actually generate the money. Now, this was a proposal that was actually brought forth by Josh Rosen, and I know you've mentioned this before, that I think you're not necessarily such a fan of having to like it because you don't care for Josh Rosen as much and how he brought it about. But it was an interesting proposal that, credit where it's worth. It was Ty Gonzer, who's a partner at Weinberg Gonzer LLP, a Southern California law firm, brought forth this idea, and then a law student, Brian Blitzer, helped as well. What they sort of proposed is the NCAA has a clearinghouse where if you want a likeness, the rights to players for, say, their likeness in a video game or for a shoe deal or what have you, you don't license individually through the players, but rather you go through an NCAA organization. Now, point number one, why is that important? Well, it's important because the fear with individual endorsements is that it becomes a backdoor for buying players. If you're a player that wants to, play for, let's say the University of Texas, there's some big oil baron at Texas that, he's going to license your endorsement for a bunch of oil commercials, and he's going to pay you $3 million as a high school athlete, or maybe 6 months into your college career, to show up in these commercials. And obviously the value is way out of proportion, and the truth of the matter is he's paying you to come to the University of Texas. You're not really getting endorsement. You're being bought to go to the school. That's the fear. What the clearinghouse does is it says, all right, you can sign endorsement deals with players, but we're going to control this as the NCAA, and we're going to make sure all the money doesn't go directly to the player himself individually on an individual basis. So it's really hard to buy an individual player in this model. And what I mean by that is, let's say you want a contract with Baker Mayfield a couple years ago to be on a shoe commercial or a commercial for car washes. I don't know. You would contract with him, and there would be a revenue split. So whatever money you wanted to pay him for that commercial, you'd maybe contact him, or you'd contact the clearinghouse. The clearinghouse, probably you would contact the clearinghouse and say, we want to use Baker Mayfield. They would decide whether or not they thought it was worthwhile, and they would contact Baker Mayfield. Of the money that you would pay for that endorsement, some portion would go to the players themselves, and it's usually a pretty good chunk. That could range from, they gave 3 examples here, but one of them, half the money went split evenly across all the players in the sport. some chunk is going to go to the clearinghouse itself. Now, that pretty much every deal has put that number at about 25%. And the reason is you need to give the clearinghouse some sort of incentive if they're the point of contact for these endorsement deals to actually make them happen, right? You don't want them just constantly go, it's not worth my time, I'm not going to deal with it. They need to make money from doing these endorsements so that they're aggressive on the player's behalf to get the endorsements done, and then they make sure they're done with quality. Then some chunk goes to the General Scholarship Fund, some chunk goes to the NCAA, and some chunk goes to the player himself, the individual player. So, maybe, in some deals, maybe no money goes to the individual player. Maybe it's all split evenly across all of the players in college football. That's not very likely because as an individual player, why would I ever bother showing up for a used car commercial if I'm not getting any individual money myself? I'm just going to rely on the pool. Nobody's going to do anything. So it's more likely, for example, that 25% of the money from the commercial goes to me, 25% of the money goes to, or 50% of the money goes to a player pool, and then maybe the remaining 25 to 50%, that gets split between the NCAA, the clearinghouse, and the General Scholarship Fund of the university. So as a player, I get some amount of money for doing this. The school gets some money for the scholarship fund. The player, the third string tailback that nobody knows, gets a little bit of money himself. And importantly, if I, as the player, am only getting 20% of the money, if the Texas oil baron wants to put me in a commercial and he wants to pay me to go to Texas indirectly through the commercial, and let's say he fronts $100,000 for the commercial, as much of money as he's putting in at $100,000, the truth is he's only $20,000 goes to me. It makes it a lot harder to buy players because I may get that $20,000 from him, but I'm also going to get my share of the giant pool. Most of the money is just going to the share. That's the idea. It's hard to buy an individual player, and if you do want to buy an individual player, you essentially have to pay 5 times or 10 times whatever money the player gets to be able to buy him. And of course, that money gets spread evenly, and so that's an extra pool of money that gives everybody else a disincentive to be bought in that manner. So the players get funds and get paid properly. The video game company has a way to contract with the players to get their rights and likenesses and put them in the game through the clearinghouse. And we do something to prevent the cheating that could become a major issue in college football. Again, there's no draft in college football. If you were allowed to bid for players freely, the schools with the most money could and would just buy all the best players themselves. There's no forced mode of parity like you would have in professional sports. So all those things have to be balanced.
So in March, a lawmaker in North Carolina introduced a bill to allow for individual players to earn money based on their likeness. To me, I think this probably means well. He even said, we're not asking for any money from the NCAA. We're not asking to take away from their piece of the pie. We just don't want these players to have it restricted. The problem is, I feel like we can't do this at the individual level. As bad as that may sound to a lot of people, it's got to be for all or none. Because if you get down to the individual level, that opens such a Pandora's box for corruption. That opens such a Pandora's box for, now we're saying in amateur athletics that, we get the individual best few players on the team have this benefit, and then nobody else really gets anything. And there is no collective bargaining agreement that could benefit the entire school, because this bill, as I see it, is 100% on the individual to negotiate their own deals and everything. And if that is the case, and y'all, again, tell me if I'm wrong in the comments, if that is the case, then EA's still not going to make a game. 2K's still not going to make a game because, like you said earlier, they're not going to go to every single player and try to work out a singular deal with each one of them just to make a college football game that's not hugely profitable to begin with.
Right. And then I will tell you from the lawyer's perspective, if I have to go to every individual player, I've got a lot more concerns too, because now I'm worried, has every one of those agreements been properly executed? Do I have the right signature for every one of those? I know that I may or may not have to operate in different state law for every one of those contracts I'm having to execute. Each one of those might have its own requirements. And also, I know that I now have 10,000 individuals that all could bring separate individual lawsuits if any of them felt like it. Nobody's going to do that. Nobody's going to play that game. So the only the only way that you're going to get a big player that's willing to operate in this space is if they can contract with some sort of bargaining entity, again, a players union, where I make one contract with the players union and they're the legal entity on the other end, and we can hash that out back and forth, and I've got one contract and I got one party that would sue me. I don't want to have 10,000 potential litigants out there and 10,000 contracts, and I'm not going to do that. Yeah, and realize too, from whatever the company is, like the video game maker, you don't want to pay me to create 10,000 contracts because that costs a lot of money. So you do need to keep that, keep it centralized. Yeah, the individual basis, in my view, if it's completely individualized, and this is just my personal opinion, I do think that opens up the Pandora's box for corruption without a whole lot, honestly, of total benefit, because the big endorsement deals that people envision taking place need to happen at a large level. Those are very difficult to actually do without some sort of central authority. And so instead, you're dealing with individual endorsements, which it's a massive Pandora's box of who is paying what individual or player to do what. And are they paying them with some sort of ulterior motive in mind?
And we already see this on the individual level with players having their hand out. College football, college basketball, it's been going on for decades, so that's nothing new. So now all you're doing is what's made kind of hard because they have to do this under the cover of darkness. Now we're just making this, okay at an individual level. That, like you said, is different from the discussion of should college athletes be get paid. This is, should we be able to work out individual deals for individual players on individual endorsements? I just cannot see that going well or ending well. So, all right, Josh, anything else on this? We said 20 minutes. I'm looking at the timer. It's 54 minutes, which means I'm going to need to do some editing. Anything else on this? Any last thoughts? And basically, I know you're not wanting to speculate, but do you think we'll ever see another NCAA football or basketball game?
I think it's possible. So I guess my final thought would be, as much as I personally really don't like the individual compensation model, because I think it does open up too much for the corruption, I actually really like this NCAA clearinghouse model. This idea that, in my view, an individual player could get something like 10 to 20% of an endorsement deal, that 50% of the money was split evenly across all the players, and then you give a little bit of money to the school and the NCAA and to the clearinghouse. That's going to help universities. It's going to help the individual players and get them some amount of money. It's good for the companies, because if it wasn't good for them, they wouldn't be paying money for the endorsement deals. So that's going to help them. And it would allow us to have a college football game. And I think right now there's enough interest in wanting to make sure players are compensated that there's a real chance that something like that could actually occur or be put into effect. So it's something that I personally would like to see. And I think there's a chance that it could happen. And you know what? If we do have some way to centrally contract with players, I think there's a real chance you could see another sports game. But I do think until that happens and companies have some assurance that they're not going to get popped with a surprise lawsuit, you're not going to see another college sports game.
Yeah, and like you said, I mean, if I'm EA or 2K, I really don't want to look at 10,000 individuals in a class action lawsuit. Even if somebody internally came up with a way they thought that could legally clear me to make it, until I've got a green light from everybody, I don't want to do it. So that's it for us, y'all, in this one. We had a lot of fun. We've been talking about doing this for about a year now. I'm glad we finally got down to doing it. There's been some other discussion about this game, a lot of discussion about this game on YouTube, because I think there's a pretty big groundswell in the YouTube and gamer cross-section community there that want to see this game happen. Maybe 2020 we can see something. Until then, you're stuck without playing this game in 4K. You're stuck playing it on your PS3. So thanks so much, y'all, for sticking with us this long. Please remember to subscribe and let us know in the comments if you think there will ever be another NCAA football game. Thanks so much, y'all. Have a great week, and God bless.